In South Carolina, an ordinary security guard, armed with minimal training and a state registration, can legally detain, arrest, and even use force against suspects with the same authority as a sheriff's deputy. How did this happen? What does it mean for the guards, the public, and the law itself? And why does South Carolina stand alone in granting such sweeping power to private citizens? Let's dive into a system where security guards aren't just watchers, they're enforcers. First, let's clarify the rules. In South Carolina, every security guard, whether armed with a gun or just a flashlight, must be registered through SLED, the South Carolina Law Enforcement Division. SLED isn't some minor agency, it's the state's top law enforcement body, overseeing everything from drug trafficking investigations to forensic labs. If you're working security here, SLED registration isn't optional. State law says you must register if your job involves deterring crime, protecting property, or even just maintaining a security presence. That means unarmed guards at a mall, armed guards at a bank, or patrol officers at a warehouse all fall under SLED's umbrella. But here's the catch. Registration isn't just a background check. It's a legal gateway. Once SLED approves you, you're not just a guard. You're a state-recognized enforcer. Now, let's unpack the law. South Carolina Code Title 40, Chapter 18, Section 40-18-110 states plainly, a security guard registered with SLED has the arrest powers of a sheriff's deputy while on duty at their assigned property. Let's break that down. A sheriff's deputy is a fully sworn law enforcement officer. They complete months of post-certified training, peace officer standards and training, pass psychological evaluations, and undergo field training. Their authority to arrest, detain, and use force is unquestioned. In South Carolina, a security guard gains that same authority, not through an academy or a badge, but through a SLED registration. This isn't a citizen's arrest. This is state-sanctioned power. Guards can handcuff suspects, use reasonable force, and make arrests on behalf of the state, all while working for a private company. But how does this compare to the rest of the country? In most states, security guards are treated as private citizens. Their authority ends at observe and report. Even if they witness a crime, they can only perform a citizen's arrest, a limited power that requires them to personally witness a felony and immediately hand the suspect over to police. A few states, like New York and North Carolina, allow guards to become special patrolmen or company police. But these roles require weeks of police-style training, background checks, and sometimes even a court appointment. South Carolina, 4 hours of classroom training, no field training, no psychological screening, just a clean record and a $75 registration fee. For context, the state requires more training to cut hair, 1,500 hours, than to grant someone deputy-level arrest power, 4 hours. This isn't just unusual, it's unprecedented. Let's talk about who can wield this power. In South Carolina, you only need 3 things to become a SLED-registered security guard. 1. Be 18 years old. 2. Pass a background check, no felony convictions. 3. Complete 4 hours of state-mandated training, 12 hours for armed guards. That's it. No high school diploma required. No mental health evaluation. Imagine an 18-year-old, fresh out of high school, with no life experience, patrolling a busy mall or a corporate campus. After 1 or 2 days of classroom instruction, they're handed a badge, a gun, if armed, and the legal right to detain and arrest. Contrast this with police officers. In South Carolina, police recruits must complete 12 weeks of academy training, plus field training under supervision. They're drilled in de-escalation, constitutional law, and use of force. Guards, they're thrown into the deep end, often with no safety net. But here's where the system gets even riskier. Unlike police officers, security guards in South Carolina do not have qualified immunity. Qualified immunity is a legal shield that protects government employees, like cops, from being personally sued unless they violate clearly established rights. For guards, there's no shield. If they wrongfully arrest someone, use excessive force, or even make an honest mistake, they can be sued personally. Their savings, their car, their home, all are on the line. Employers might carry liability insurance, but that doesn't stop lawsuits from naming the guard directly. And unlike police unions, which fiercely defend officers, security guards often face legal battles alone. Here's another layer of complexity. Guards aren't legally required to act. Their obligations depend entirely on whatever their company and client decide to put in the post orders. Police officers, they're tasked with enforcing laws and protecting the public. But under U.S. law, unless a specific statute applies, they have no automatic duty to protect any individual citizen from harm. You heard that right. Even if a cop watches a crime unfold, unless state law says otherwise, there's no guarantee they're legally obligated to step in. And if they don't act, unless it violates a specific law or policy, they might not face any discipline at all. Security guards, though, they walk a different kind of line. Even without a legal duty, if their post orders say intervene, they have to, or risk being fired for insubordination or negligence. It's not the law holding them accountable, it's the company policy. And failure to act when expected could cost them their job, their paycheck, and even their future in the industry. For example, a guard at a grocery store might be ordered to observe and report shoplifters. A guard at a high-risk construction site might be told to physically confront trespassers. This creates a patchwork of responsibilities. Two guards with the same SLED registration could face wildly different risks based on their employer's policies. And if a guard does intervene, they're personally liable for any fallout. If they don't intervene, they could be fired for neglecting their post orders. It's a legal tightrope with no safety harness. Now, let's talk money. Sheriff's deputies in South Carolina earn an average of $62,000 per year, plus benefits like health insurance, pensions, and union representation. Armed security guards, they make about $18 an hour, roughly $38,000 a year before taxes, with few, if any, benefits. For unarmed guards, it's even lower, $15 an hour. MIT's living wage calculator estimates a single adult in South Carolina needs $22.15 an hour to cover basic needs. Many guards are barely scraping by, despite facing risks comparable to law enforcement. Why the gap? Because guards are private employees, not public servants. Companies profit by keeping labor costs low, even as they demand deputy-level authority from their workers. To make matters worse, South Carolina has a thriving underground market for unlicensed guards. Some companies dodge SLED requirements by hiring observers or customer service associates, roles that sound harmless but often involve security work. These unlicensed guards operate illegally, with zero training or oversight. If they're caught, SLED can fine their employer up to $1,000 per violation, but many companies gamble they won't get caught, leaving guards and clients exposed. Let's revisit training. South Carolina requires unarmed security guards to complete just 4 hours of state-mandated instruction. What's covered? Mostly legal definitions. What constitutes trespassing? How to make an arrest? And a brief overview of use of force. Compare this to police academy training. Constitutional law. When can you legally search someone? De-escalation. How to calm a volatile situation. Firearms proficiency, hours of range time and safety drills. Ethics, navigating conflicts of interest. Guards get at most a fraction of this. They're taught the what of their power, not the how or why. The result? Guards acting on incomplete knowledge, escalating situations that could have been resolved peacefully. How does the public view these guards? For many, they're rent-a-cops, underpaid, undertrained, and overstepping. Others see them as legitimate authority figures, unaware of their limited training. This confusion creates tension. A guard's uniform and badge mimic law enforcement, but their skills and accountability don't match the image. When conflicts arise, civilians often don't know their rights or the guard's limits. Critics have called for reform for decades. Proposals include requiring guards to complete post-certified training, mandating psychological evaluations, extending qualified immunity to registered guards. But reform stalls. Private security companies lobby against higher costs, and lawmakers argue stricter rules would shrink an already understaffed industry. Meanwhile, guards remain trapped in a system that demands they act like cops but treats them like disposable labor. So, what's the takeaway? South Carolina's security guards live in a paradox. They're granted deputy-level authority but denied deputy-level training. pay or protections. They're expected to enforce the law, but left vulnerable when things go wrong. For guards, the message is clear. That SLED badge is a double-edged sword. It grants power, but without the safeguards sworn officers enjoy, one mistake can destroy your life. For the public, it's a wake-up call. When private companies wield state authority, accountability blurs. Who's responsible when things go wrong? The guard, the company, or the state? And for lawmakers, it's a question of priorities. Is this system fair? Is it safe? Or is it time to rethink what we ask of security guards and what we owe them in return? If you're thinking about becoming a security guard in South Carolina, check out my video on how to get a security guard license in South Carolina 2025 next. Don't forget to like and subscribe for more guard guides and be safe.